John, we mentioned earlier on in the when we were talking about overtreatment or excessive care recommendations about reviews.
Yes.
So it brings us on to the subject of note keeping. Now, I know certainly when the GCC first came into operation, note keeping was in every single. There would not be a case that didn't have a note keeping charge, and that's changed slightly with the Spencer High Court judgment. Now, but note keeping is still important.
Yeah, I mean, the reality is it's still in every case anyway.
Yeah.
The difference is that if a case is centred around note keeping and only note keeping, and it's an isolated incidence of note keeping, then the Spencer case sets out fairly useful guidelines to all health professionals that says that an isolated incident of a failure to take proper notes wouldn't amount to unacceptable professional conduct. But if you have a sustained failure to take notes over a course of treatments or a number of patients, then it can amount to unacceptable professional conduct. And the reality is, I can't think of a case, in certainly the last 10 years or so, where there hasn't been some reference in the allegations to note keeping. It always crops up.
Yeah.
In pretty much every case.
So, what particular areas do you think that we need to be particularly mindful of in relation to note keeping?
Well, the first is it depends how you take your notes, because some chiropractors use computerised systems, some chiropractors are handwritten notes. We've had a case recently where one of the allegations was that the notes were illegible, couldn't be read. And that in itself was a failure to take proper note keeping, because an incoming locum wouldn't be able to read them. I
think many of us would be in trouble.
I think you're probably right. So if my handwriting's anything to go by, it's probably illegible as well. But so that's a basic starting point. If you're going to make notes, make sure they're legible. If you're using a computer, obviously it's different. But the sort of things that crop up regularly are starting really from case history to the examination, what you did, what you didn't do, the results of the examinations, so the orthopaedic and neurological examinations, quite often that crops up.
On that point, a lot of chiropractors I've noticed, if they get a negative finding, they don't record
exactly
it.
The point I was going to make.
I think that, you can sort of get away with that, but it's much better. Your notes as a chiropractor are your best form of defence. And
I've never seen a criticism by one of the GCC experts that a negative or nil finding should be recorded. So I don't think you need to go that far personally. In an ideal world, you'd note every single thing that you did in every test, positive or negative.
But couldn't that if it shows that you've done it, right? So it might be negative. So that if it shows, then you've got a record that you've performed a test.
That's the ideal. Yes,
yeah.
That's best standard is to show that you've done the test. Yeah. Now again, on a lot of people's pre-printed forms, they will have all the tests on their examination form, and it's quite useful to be able just to go down that form and tick a box to say positive, negative. And obviously, if there is a positive finding, you've got to record what that finding is. But that's increasingly cropping up in my experience in PCC cases as a failure. It's the orthopaedic and the neurological exams. It's something that the GCC seem to be fairly hot on at the moment, and it's not so much. I'm probably straying into a new topic. It's actually the need to do those examinations rather than the failure to take a note of them, and that's something that. Do you want to discuss?
No, that's okay, because I think it does naturally flow, because we're talking about errors of omission rather than errors of commission.
So what will happen classically is that there will be two allegations. One will be you failed to do sufficient appropriate neurological examinations, in that you failed to do whatever test, and then the second part is, and you failed to record the fact that you failed to do that test. Yeah. So it comes in two parts, and it's pretty standard for the GCC to plead it in that way. But the starting point is, what do you need to do at an examination? And certainly in my experience, that's something that's cropping up a lot at the moment. So the experts that I've already referred to, they're highly critical, particularly from my experience of the neurological side of things.
Yeah.
Orthopaedic testing, range of motion, that sort of thing, tends to be fairly routinely carried out, in my experience, with most chiropractors. But the neurological testing and the extent to which you should perform these tests seems to be something that's cropping up a lot. And you as a chiropractor will know more about that than I do.
Yeah, I mean, it's quite ironic, really. It's chiropractor, when you think the whole essence of chiropractor, what we're assessing, what we're working with is the nervous system, but we don't assess it. But I think what you're talking about, and that in relation to anyone who has radicular symptoms, anyone who has neurological symptoms, that you do a neurological exam and do a complete neurological exam. Right. So it's certainly on their initial presentation. So if you do reflexes, you do your dermatomes, you do your myotomes. If it's all clear, then fine. But if you do find positive findings, then you retest. Would that cover it?
Yeah. And again, it's not for me to tell you which tests to undertake or which tests you should or shouldn't do. But certainly the sorts that's your job. But the sorts of things that are coming up is that there's a bit of tingling in one of the legs. Is it bilateral? Is it lateral? Is there cauda equina? Is there spinal stenosis? Those sort of things are cropping up a lot. And it's not so much as you say, do a hammer test or do a Faber test or whatever it might be. You've got to go through the whole range because the criticisms that certainly my clients are facing is not just you didn't do the neurological test, it's you didn't do an adequate neurological test.
One. Yeah. Because by the same token, you don't be doing tests just for the sake of it because you think, okay, I'm doing this for someone else. You want to do something that's appropriate. But I think most of our audience will understand when it's appropriate time to do a neurological test if there's neurological symptoms.
Yeah.
You did touch on, and I think it's a good point, is cauda equina. It's something that we're seeing a little bit through the fitness practice hearings, but certainly in malpractice and coming from outside of the profession is that chiropractors are getting drawn into cases that involve cauda equina. The person may have seen a chiropractor and the patient or the person has gone after the hospital or the GP, and because they saw the chiropractor, they come after the chiropractor. Right, so certainly it's an area to be mindful of, and if you suspect cauda equina, it's a medical emergency, you need to act on it very quickly, and it's one of those things that it's just, again,
it just seems to be cropping up
just recently.
Yeah, I mean there've been a number of cases where civil cases where big damages have been paid out for medical negligence for cauda equina, and I think it's something that that patients and claimant solicitors have picked up on and are pursuing. And obviously, if they can get a disciplinary finding on that front, it makes a civil claim a lot easier and less costly to pursue.
Yeah, exactly. And the way the legal systems work, they go for everyone. So. Okay.
So I digressed away from your original
I know. I was just going to bring
notes.
that back to notes. So the areas that you've mentioned, history. We've mentioned examination.
Yep.
We spoke about review, and one of the things that's often what is an adequate review? Because people say, I've done a review, but in the eyes of the GCC, it may not be an adequate review.
It depends on the patient. It depends on the progress that the patient's making. Certainly in my experience, the committee will look at the SOAP notes for the treatments between reviews, and they'll be asking themselves, what's the patient saying subjectively? Is the patient improving? Is the patient getting worse? What's the chiropractor observing? Etc., etc. So you've got to make. I mean, the SOAP notes are an integral part of any note-keeping system, and it goes without saying. The notes for each appointment need to be relatively thorough. There is a habit, certainly from what I've seen, of cutting and pasting. Certainly on the computerized systems, have been able to. Forgive me, I can't remember what the exact word is, but just repeating the treatment or the notes from the treatment before. Yeah, so
Same as last time.
There we are. But I've seen that a lot, and it does raise an eyebrow. And people think we couldn't have done this. Surely the patient couldn't have just said fine, etc. on each appointment. So the SOAP notes are an important part. When it gets to the review stage, you're asking yourself, what's the progress? Now, a lot of the time, if progress is good and things are going according to plan, you don't actually need to do a review, providing you're at the right stage of treatment. And the GCC won't be critical of you for not reviewing if things are going according to plan. It's when things start going wrong that they start saying, well, this is what you should have done at this stage. So you should have reevaluated, sat back, thought about your original plan of care, thought about your diagnosis. Is there a differential diagnosis? Talk to the patient, etc., etc. And there's no specific format for any review because it is patient specific. What I would say is if you're doing what we call the formal review every 12 sessions, you've got a baseline at your first appointment, which is your examination. Orthopaedic tests, if they are range of motion, do them again. Do them at the 12th session. Has there been some improvement? You can't compare progress unless you do that review and compare it to the original baseline. Similarly with neurological tests, if there are deficits at the first appointment, repeat them on the 12th if you haven't done already by that stage. So it's common sense to a lot of degree. And again, I don't want to encroach upon what should or shouldn't be done. But from a lawyer's point of view, the problems that we see is that there doesn't seem to be enough attention paid to what's happening between appointment 1 and appointment 12. There is a general acceptance that, of course, there is an up and down with all sorts of treatments, and as long as that's within an acceptable measure, that's fine. You don't have to suddenly stop everything and start again. But if you've got a patient that's just not responding and is just not getting better subjectively or even objectively, the GCC want you to sit down and think again. And that's something that just crops up in a lot of hearings we do now.
And you document your thought processes. You say, patient hasn't responded to this type of treatment, care, so I'm going to give a different type of care. It may be different exercises, it may be different adjustments, and if nothing is working, then it's incumbent on you to tell the patient that and refer elsewhere.
Well, that's a good point actually, because if we go back to the 3-phase model of care, and this is something I think it's important that there is a point of difference in the different phases of care rather than just the number of visits. So going, okay, I'm visit 12, I'm in my initial intensive care, it's visit 13, okay, I'm in corrective care, right, or I'm in rehab, and you're not doing anything differently. And so this is another purpose of review, is that you're looking at your review, and I think engaging with the individual, see what are their goals, sitting down and some good measures to use, patient-reported outcome measures, so PROMs they call them. So the patient is saying, okay, these are the changes I'm noticing, and then asking them what their goals are, so that you're engaging with them about their continued goals, and then continuing their care. So that you're taking them on the journey, or you're going on the journey together, and review is integral for that. And so documenting everything and doing a decent exam, so that because I would say that even if someone is doing well, that you can get that would be symptomatically well. We want to see they're doing functionally well. And so doing review, you're not going to get criticised for doing reviews, you're going to get criticised for not doing reviews. So doing them on a regular basis is key, and then because it gets to the next point is consent. Now that could be a whole big issue, but I suppose the important thing is documenting consent, but also the review, so that you're at the review, so you're getting consent for ongoing care or going to the next stage.
We get a lot of patients that say, I came in, he did the same thing every time, she did the same thing every time, I didn't really know what was going on, I wasn't getting any better, and it just felt like I was being rushed in and out, and it was the same treatment. That's a classic complaint that we get, and I think what you just said there about sitting down with the patient and talking about their expectations and their goals at a certain stage within treatment is, and to document that. I mean, for me as a lawyer, there's gold dust. I don't see that very often, and it would just be so easy to be able to refute an allegation that things were just carrying on regardless, because that's the underlying criticism. It's that you've just got the patient in, you don't really care about what's happening. You're just going to carry on caring for them and treating them in the same way regardless. That's the underlying thrust of the complaint.
For the benefit of the practitioner.
For the benefit of the practitioner. For the benefit of the practitioner.
Yeah.
If you were to put in your notes what the patient's preferences were as far as treatment is concerned, then the word preference is used in the code of practice with regard to patients, and if that's documented in a review that the patient's preference was to carry on doing the same thing, then, as Jonathan says, that's gold dust to a defence lawyer.
And it also forms part of the ongoing consent process. So are you talking about the ongoing consent or the original?
Well, I suppose both. When do we need to record consent?
You don't need to record consent ever, strictly speaking.
That's a bit controversial.
Yeah. Consent,
Especially for a lawyer.
but that's the reality. It doesn't have to be recorded. In practice,
I can hear the shredders going now with these consent forms.
In practice, it should be, and we would advise everyone to record it, because it's the recording of the consent that quite often justifies the fact consent was obtained. That doesn't in itself prove consent was obtained, because there's various other things you have to do. But not recording consent makes it more difficult for a practitioner to say they got consent, put it that way. So when I say it doesn't have to be recorded, that is the legal position, but it doesn't help you. So the advice certainly I'd give any of your members is to record consent. And there are various stages you need to make sure it's recorded at.
That's the point I wanted to make, because there are so many cases that we come across where one form of consent is given, and it's given prior to examination, and it's given as a consent to examination and treatment.
And X-rays.
And X-rays, anything you like. But of course, that's impossible. You cannot give consent to treatment when you don't know what treatment is being recommended. And this is why I was talking earlier about better documentation of report on findings, because the report on findings should document that the treatment, the proposed, sorry, I keep saying treatment, I mean care. The proposed care has been explained and understood, and that the patient can ask any questions if they don't understand, and then they sign that they understand it and they want that care. And there are many experts that, the few that the GCC have as experts who will poo-poo the idea of consent for care being on the basis of a consent for examination, and I'm afraid they're right. So make sure you get your forms in place so that it's not just consent for examination, but then at a later stage there is consent for care and or treatment.
X-rays, and then there's the whole issue of GDPR as well.
Yes.
But
another topic.
That's another topic, exactly. But just make sure you get that. So, and then consent for ongoing care, because like you said, that's the gold dust.
Yeah. Gold
rings gold dust.
Yeah. I mean, the reality is, once a patient has received a form of treatment, there is a acknowledgement that patient might expect the same treatment at the next visit. So the consent is ongoing. Obviously, if treatment changes, and again, we quite often get cases where patients are saying, I complained about the fact that I wasn't getting better, but they just carried on regardless and didn't explain to me what was going on. And again, consent tends to overlap in those circumstances within appropriate treatment. So if you've got a patient saying, look, what's happening, things aren't working as I want them to, they are in effect withdrawing their consent to carry on. You've got to be very careful in those circumstances.
It's an ongoing process.
Yeah, and make sure that you say, well, look, are you happy with this? As John said, get it in writing. Are you happy with us to continue, even though it hurts? Are you happy with that? So,
I mean, what I often do is, if I'm doing something slightly different or a different area, right, without sitting down and going through the whole thing, but just explain it and say you're happy to do that, and then I just write consent and stick a tick on the note to say that I've had that conversation. Is that acceptable?
Yeah, I mean, the consent needs to say it's much broader than that, because it has to be informed consent.
Yeah.
But the patient actually has to understand what you're talking about, and we as lawyers, and certainly some practitioners, tend to be quite verbose in the way we explain things. So getting consent is not just a tick. It's important that all your members realise that for consent to be properly obtained, the patient has to understand exactly what you're proposing, and it's incumbent on you as a practitioner to make sure they understand that. It's no good turning around and saying, well, I told them and it's not my fault if they did or didn't get it. They have to understand that at the end of the day. So the recording aspect of consent is a useful indicator that consent was discussed. It's a useful indicator that consent was given, but it's not by any means the be all and end all. Consent
Sure.
consent is a much broader topic, and as I said, the key really is just to make sure that they understand in simple terms what they're signing up to.
Yeah.
So many of the cases we get and the complaints that are made are based upon poor communication
Yeah.
between the chiropractor and the patient. And if you can make sure that you have that good communication, and most chiropractors do, they're warm, empathetic people, and they're carers, and they do what they do because they love it, and they want to make people, their patients, have a much better quality of life. But if you don't communicate well with your patients, then you are much more likely to get a complaint.
Well, if you look at the fitness practice report, communication is the biggest area. Everything stems from that, and that's a good point. So, what I was referring to before, John, was just the context of when you're in someone's ongoing care and you're going to do something different. You do explain it, but you might be, because I remember seeing a case many years ago about someone they'd come in for a back issue and then they wanted to work on their knee,
Yep.
and then they got accused of they didn't have consent to their knee. Now, we don't want to go too far, but just to be mindful of, if you're going to do something different, to have a conversation.
Have a conversation. You don't have to go back and get your original consent form altered or changed or amended, but you do have to show, and the duty is on you to show that you explain things
Yep.
to the patient. And of course, the more you have documented, the easier it is for us as lawyers to be able to not that the job's on us to prove it, but to rebut any suggestion that you didn't explain things.
Yeah. Okay. So, in summary, the areas of get a decent history, record your exam, and do an appropriate exam.
Yep.
Make sure you're getting consent for at the outset and on an ongoing basis.
Yep.
What their preferences are.
What their preferences are.
So-
Decent reviews, and then engage with the individual at the review in terms of what their goals are.
Yep.
And recording subjective and objective, because rather than just a list of adjustments
Yep.
on the ongoing visits, subjective is one of the key things. And then recording any objective exams that you do in between,
Yep.
because we've all seen those files where you've just got please don't use ditto marks. We've got files
As above is
or
the
as
problem.
above.
Yeah.
or anything like that. So record exactly what you do.
Yep. And,
Okay.
and I think you're absolutely right. Subjective shows that you've had a conversation.
Yeah.
And quite often it can be things like going on holiday or been to a wedding or something very personal
Yeah.
about the patient to show you're actually talking to that individual
Yeah.
rather than just farming out treatments along a bench day in, day out, which is again what the allegation effectively is. People say that it's a one-size-fits-all approach.
Yeah.
And if you can show that you have a personal relationship with the patient by demonstrating that you know something personal about their life, put it in the notes.
Fantastic. Yeah. So it doesn't have to be an essay.
Doesn't, no.
Okay.
Yeah.
Yeah.
Great. No, that's most helpful. So I think one of the key things that there's some documents that people should read, and probably number one is the code and the guidance. We've got the 6 guidance documents on the GCC website and the code, and it changed in 2016. So there's really no excuse for not knowing it now.
Yeah.
Great, excellent. So thanks, John and John.
Thank you.
It's been most helpful, and this may be a slightly different approach for you, but what we wanted to do is to have the input of John and John, who look after our members, certainly in the legal context. It's not a couple of lawyers telling you how you should practice, but just to make us alive to the issues that do crop up, so that we can be mindful of those in a practice and put measures in place to make sure that you don't get to meet these 2 lovely guys. So thank you for listening. I hope you found this really useful, and if you have any questions anytime, do contact us and down at the office. So yeah, from me, Paul McCrossan, and from John and John, thanks for watching.
Thank you.